Okay, so at this point, we'll begin the program proper. And what we're going to start with is the first module on green laws. And this module covers a number of laws, six if I'm not mistaken. And, they're all kind of falling together under this module and referred to as green laws. That's for an obvious reason. They focus on the protection, conservation, utilization, and development of forests, as well as other land-based natural resources, including wildlife. Okay, it's obvious that they use green, and this nomenclature, by the way, is not unique to us, not unique to me. This is very well used in environmental laws among circles here in the Philippines. Okay, so just so you're aware. All right. So as I said, we're going to be covering about 6 laws, and to make things a little easier, parang medyo hindi masyadong madugo, so to speak. I thought it best to split up the 6 laws into about 4 lessons. Okay. In fact, I think that's how they're organized in the curriculum that you may have received for this program. All right. So these 6 laws, as I said, will be broken out into 4 lessons. The first lesson will cover the revised Forestry Code and chainsaw. And those are 2 that we're going to start with in a little while. And for those 2, I've broken them further into 2 separate sub-lessons for each of the 2 laws. All right, so there's lesson 1A for the Forestry Code and 1B for the Chainsaw Act. All right. Lesson 2 will focus on the Wildlife Conservation Act. And lesson 3 will be on 2 laws focused on mining, the Philippine Mining Act of 1995 and the People's Small Scale Mining Act. And then the last lesson, lesson number 4, will focus on the National Integrated Protection Areas, or NEPAS Act. All right. In terms of how each law will be presented, first of all, we're talking about the rudiments, the fundamentals of these laws. And ang gagawin natin, we're not going to be going to each of the minute details of each law, as that would take a long time. Plus, medyo that may steer away from the objective of this course. Okay, the objective of this course, the Special Certificate in Environmental Laws and Investigation, okay, is, as the title implies, not only on the laws but on the investigation. So what we're going to be focusing on would be areas that are relevant to investigation. All right. So having said that, ang gagawin natin for each law, at least we'll attempt to do it for each law, is that we'll start with the basics as to the rationale behind the particular law that we're discussing. Okay. Why was it put in place? What was its basis for coming into place? And then secondly, how the law plans to make it happen, how to deliver, how to make deliver on its promises, so to speak. Okay, so that's the second part. Okay, and then the last part is where we begin to focus mostly on the investigation part. That's the area that would look at the criminal offenses and the penalty, but mostly on the elements as to what makes it a violation. You know, what are the elements of the offense? Okay, things that you would need to know as a environmental law enforcer. You know, what are who could be liable for the offense, for the crime? What specific acts would they have had to commit to be considered in violation, and what, if any, qualifiers may be necessary to ensure that indeed it was a criminal violation. So yun ang tututukan natin on the third part. Okay? So with that said, I think we're ready to go. Next now, we're going to begin with lesson 1. And as I said, there's 2 sub-lessons underneath. And we'll start with the first one, lesson 1A, Revise Forestry Code. Revise Forestry Code. The specific title of this law is the Revise Forestry Code of the Philippines. It is otherwise known as Presidential Decree number 705 as amended. So now let's begin to understand why this law was created. Okay, the rationale behind it. Ang tinatanong talaga natin dyan is what is this law all about? Okay, what is it all about? So to help us answer that, we look to the section of the law that provides either the declaration of policy, or sometimes even the title provides that. But in most laws, you'd find that in what they refer to as whereas clauses. These are usually found, the whereas clauses and the declaration of policy are usually found in the very beginning of the law. Okay, and whereas clauses, which this law has, essentially provide a way to understand why this law was created, because sinasabi doon kung ano yung situation ngayon na it's necessary for this law to be put in place. Okay, so kumbaga sinasabi dahil ganito yung kalagayan, ito dapat ang gawin, parang ganyan na sinasabi. So whereas this is the situation, there is need to do this. Okay, so parang ganyan ang purpose ng whereas clauses. So in PD 705, there are 4 whereas clauses. And let's go through each one of them. And just to conclude, kasi medyo flowery words minsan ang lumilitaw dyan sa mga either declaration of policy or whereas clauses. So they're not really as specific sometimes. Okay, so let's try to make sense of it, right? And this is what we're actually looking at here. Ang sinasabi dito really is that for a state to be able to properly classify, manage, and utilize, or at least allow for the utilization of lands of public domain, there's a number of things that need to be done. But before we move on to those things, let's just first talk about lands of public domain. Excuse me. All right. So lands of public domain, okay, the law says are classified into agricultural, forest or timber, mineral lands, and national parks. Okay, these are lands that are owned by the state. Okay, these types or classifications are precisely what we were referring to earlier when we said that the state, okay, in order for it to properly classify, this is the classification that we're talking about: agricultural, forest, mineral, etc., etc. Okay, and because they're owned by the state, generally they're not for sale. They're outside of the commerce of man, so to speak. Okay, with one exception. Okay, agricultural land is one that could be alienable as allowed by the government. Okay, and when we say alienable, we're really talking about its ability to be transferred from one person or entity to another, and that transfer, the most common means of which is sale. Okay, all right, so let's move on. So again, in order for a state to properly classify, manage, and allow for the utilization of lands of the public domain, there is a necessity actually to assess as well as reassess the multiple uses of forest lands and resources before any of the utilization, before it can be allowed for utilization. Okay, so the multiple uses here, we're not just talking about the different types of ways it can be used, but how many times it can be used. Okay, and what we're referring to here when we say multiple uses is pertinent to forest lands. And forest lands um, includes, as provided by this law, the public forests, the permanent forests or forest reserves, and forest reservations. Okay, and then this law, PD 705, goes further to define what public forest is. Okay, it says that public forest is the mass of lands of the public domain not subject of the present system of classification. Okay, for determination of which lands are needed for forest purposes. Alright? So medyo may pagka-technical na yan. Probably not super critical to know quite just yet, but it's something that you could include on your list of things to kind of study over time if your focus is on green laws. Okay? So, but for now, it's not the most critical focus of ours, so we're not going to delve too deep. In fact, we're going to move on at this point. Alright? So besides this necessity to reassess the multiple uses of forest lands, this whereas clause, in attempting to answer that question of what this law is all about, also goes on to say that it is also imperative to place emphasis not only on the utilization that we just discussed, okay, but more so on the protection, rehabilitation, and development of forest land. Okay, medyo may pagka, I mean, if you look at it superficially on the surface, okay, medyo may pagka contradiction to kasi you know we're talking about forest lands, which is part of the lands of public domain, and which in general are very very important lands in the country. They're kind of sensitive. I mean, they're very rich in resources, which in a way makes them sensitive because that can all be depleted if if it's not protected, right? So again, the law talks about protecting it, and rehabilitating it in cases where maybe it's falling apart or it's declining. Okay, and even further develop it. So it's talking about protection of this very important resource. Okay, protection of. So it's almost saying a lot of prohibitions there as to what people against people accessing those resources. But at the same time, and this is where the contradiction comes in, it is also talking about putting an emphasis on the utilization, okay, on the use of these resources. Okay, so there you have it. There's a contradiction. Okay, so in any case, it's interesting that this law kind of talks about that, so we can have a better understanding as how that balance can be put into effect. Okay, now let's move on before we conclude this rationale. The last whereas clause is kind of an interesting one because it essentially aims to put a period to the question as to why this law is needed at the time. Kasi luma na tong law na to, as I said. I don't know if I said it yet, but it's I think it was 1975 when it was put into effect. So a lot has happened since, but nonetheless, during the time, what was apparently happening in the situation, in the environment, was that the laws at the time that provide any kind of governance on forest lands just weren't responsive. So this last whereas clause aims to kind of put the last nail on the coffin and saying that the present laws and regulations governing forest lands are not responsive enough. Okay, which again puts to rest the need for the implementation of this law. So now let's go back to why, or at least to our first question, our primary question on this slide is, what is this law really all about? Okay, and just to simplify things based on these what we read here on the whereas clauses. Okay, I'm sure you're already picking up a lot based on what we just discussed, but in essence, what this is really all about, what this law is really all about is forest lands. It's all about forest lands. Okay, all about protecting it, rehabilitating it, and developing it. Okay, just the same, which may sound like a contradiction. Okay, the ability to use it, utilization, protection, rehabilitation, and development of forest lands. That's what this law is all about. So now let's talk about how this law provides for the objectives that were discussed in the reasoning, the whereas clauses. All right. So what we're going to look into here are the provisions of the law that provides how the government aims to achieve those goals. Okay, and that's the reason why this is entitled organization. More importantly, the question that we are hoping to answer here is, how does this law provide? Okay, so let's talk about that. All right. So since we're talking about organization, I think it's important to first discuss how the government is doing things today. What entity did they put in place? Okay, and the creation of PD 705, the first thing it did was to gather up all of the agencies with some responsibility in forest development. Okay, at the time there were 4 that were identified: the Southern Cebu Reforestation Development Project, Bureau of Forestry, Reforestation Administration, and Parks and Wildlife Office. What the law did, PD 705, is to essentially merge all of them and created a single bureau, okay, called the Bureau of Forest Development. Okay, so as I said, the agencies, well, at the time anyway, they were that's all of them. So all the forestry agencies at the time in 1975 were merged into this newly formed bureau under the DNR. Okay, it is under the control and supervision of the Secretary of the Department of Environment and Natural Resources, and its purpose, probably its sole purpose, but surely its primary purpose, is that of implementing the provisions of PD 705. Okay. So as to the Bureau's authority and jurisdiction, the law has this to say. It says that it has authority and jurisdiction over all forest land, grazing lands, and all forest reservations, including watershed reservation, presently administered, of course this is 1975, so it would have been at that moment in time what were being administered by other government agencies and instrumentalities. Okay, so this paragraph in the law is interesting because it identifies, of course, the different classification of lands for which the Bureau has authority and jurisdiction over. Okay, including forest lands, which we have already defined at least twice in earlier slides. Okay, but goes on to also talk about grazing lands and all forest reservations. Okay, so those are the 3 bodies of land, or at least forest lands, that it is referring to. Okay, but it also goes on to include watershed reservation. So we'll talk about that in a minute. But let's first look at what definition it has on the 2 other lands with greenery that are introduced in this provision of law. Okay, as I said, we've already defined forest land, so let's see what it says about grazing land. Okay, so grazing land, I think we have a kind of a general idea as to what that is. It's really the place where you bring in yung mga kambing, baka, diba? It's usually like a flat land with many vegetation, or at least not necessarily flat, but basta, it's a place where, cows and goats and whatever other domesticated animals could be brought to where they can graze, to be fed and, etc. Okay, so grazing lands. Now, a much more legalistic definition is this, that it refers to a portion of the public domain which has been set aside, okay, specifically for this purpose. Okay, and it is done so in view of its suitability based on its topography and vegetation. So when we say topography, it's really talking about the characteristic of that piece of land. Okay, It could be hilly, maraming mga hills or may mga bangin or whatnot. So in those cases, probably it's not suitable as a grazing land. But if it's flat enough, kahit na may mga konting hills, it might be suitable. And of course, dahil grazing land to, it's where all these domesticated animals would feed. There has to be vegetation. Okay, so and see it says here for the raising of livestock. All right. So yeah, and that's the legal definition of what a grazing land is. And forest reservation naman, I think we all know what forest is. It's also been defined already more than once. But what makes a forest reservation? Okay, it becomes a forest reservation when the president of the Philippines reserves it for any specific purpose. Yun lang, ganun lang kasimple. And that's the reason why, I mean, as the name implies, it's a reservation, a forest reservation. Okay? So now let's talk about watershed reservation, which does not kind of fit in the category, di ba? Parang all we've been talking about here so far have been, lands that are either forested, or forest lands, or have some kind of vegetation on them. So where does watershed reservation come in? But let's first define what watershed is. Okay, a watershed is parang ano yan eh, parang what's the right one? Funnel. Parang funnel yan eh. Di ba a funnel is what you would use when you're changing oil in your car? After you've emptied the engine of the dirty old oil and you're ready to pour new oil, you would use a funnel to make sure na it doesn't, all the oil that you're pouring in doesn't spill. Kasi yung characteristic ng funnel, di ba, yung sa dulo niya medyo narrow, maliit. That's where you would put, that's the end that you would insert into the opening in your engine. And then the opposite end naman medyo wide siya. Okay? So that when you pour oil, hindi masasayang, nothing gets spilled because it can capture more. It can capture more of what you're pouring in. So that's a funnel. And how that correlates or how that compares to watershed is this. Okay, watershed, the term medyo confusing kasi you're thinking kind of like a tool shed. Diba yung if you have a big house, you have a tool shed in the back, parang maliit na bahay siya where you would keep your tools. So maybe you're thinking watershed, maybe it's the same where you have a big tank of water, and that's a shed for your water tank. Thus a watershed. No, but that's unfortunately not the case. Okay, it's a lot more. It's probably a lot better to kind of refer to it in the same example I cited earlier, or at least when I was describing funnel. It's probably better to look at it in those terms, okay? Because a watershed, like a funnel, essentially gathers up or collects all of this water, okay? So nothing gets spilled, so to speak, okay? But the kind of water that it collects, where it gets aggregated into, are actually water that comes from various sources. For example, here in our region in Asia, we have the monsoon weather, usually the second half of the year. So there's rains everywhere on flatlands, and of course there's some on the mountainside and even on the top of the mountain. So for rain that drops in those mountains, syempre, because of the law of gravity, it's gonna flow down somewhere, right? Some may become parts of a temporary waterfalls, and some may seep into the earth. But again, because it's up there in higher elevations, it'll eventually find its way to lower elevations. So where it kind of aggregates is where it ends up in. Okay, so that's one source. Another source could be creeks or rivers that are slightly higher elevation. So yung downstream niya is the lower elevation. So water flows downstream, and it'll eventually aggregate somewhere, right? And yung mga creeks that we're talking about, they're not necessarily permanent creeks. It's just because of their nature. They're kind of ukit siya sa earth. When it rains, or where there's excess water from whatever source, that's where it finds, that's where the water ends up, and it kind of flows wherever that creek leads to. Okay, so another source I kind of mentioned earlier is water that seeps into the earth. And for higher elevations, that water could also still move towards the lower elevation. And the better way to describe that kind of water that's under the earth is something that we all know. Kasi dito sa Pilipinas, in Manila, we don't have to worry about it kasi may Maynila and so on and so forth, that the government has sponsored the building of infrastructure that would take water using pipelines, from reservoirs to our homes, right? But in provinces, that may not necessarily be the case. Many times people are having to find their own sources of water on their own without, say, there's no pipeline that they can tap into or anything like that. And the most common source of water, of course, is the water table under the ground. So people are digging, or inserting long pipes to tap into that water table, and then you have a jetmatic or pump on the end, on the surface, that you would use to suck water from the water table to, towards you, so you could use it for whatever purposes. Okay, so that's the water table I'm talking about. Many times it could be stagnant, hindi naman siya gumagalaw, andyan lang siya. But many times, like I said, in higher elevation areas, that continues to flow because of the law of gravity. So all of those sources would, in many cases, end up aggregating into one quote-unquote funnel. Okay, and that funnel is a watershed. Okay, it collects all that water. Okay, and then it also has another end that delivers that water somewhere. Could be a bigger body of water, ocean, whatever. Okay, so that's a watershed is. So a watershed reservation is a forest land reservation established precisely to protect or improve the conditions of that watershed, and so far as its ability to aggregate water, the water yield that it's talking about. Papasok na tubig, it has, it's created to improve the conditions so it can be effective at gathering that water. Not only that, but to also reduce sedimentation. And I think the easiest way to describe sedimentation in this case is parang nabubulunan. So when we say reduce sedimentation, it's to prevent it from mabulunan. Okay? Kasi sedimentation refers to sediments. Sediments are rocks, gravels, parts of the earth, whatever, that usually settle in the bottom of a body of water. So if a body of water has currents, flowing water, many times itatangay niya yung mga sediments na yun, right? So it'll take it wherever the current goes. So naturally, the watershed is the aggregator. It's sort of the end of the current, okay, the flow of water. So all of the sediments that the flow of water carries has the potential of ending up and building up in the funnel, in the watershed. So itong reservation, this watershed reservation, was created precisely to reduce that from happening, para hindi siya mabulunan. Okay, so that's what it is. Now let's talk about the responsibilities of the Bureau. What I'm gonna share with you really are just a few of the many responsibilities it has. Okay, itong mga responsibilities na to are specific to the purpose or the objectives of this course. So yun lang ang tututukan natin as far as the Bureau's responsibilities are concerned. Okay, so let's move forward. Excuse me. All right, so the first one I want to share refers to its role of protecting, developing, and managing forest lands, but not limited to those three activities. But also, kasi yung three activities na yon, ilang beses na natin na-mention din yan over the course of the last few minutes. Okay? There's two new activities that it mentions here as a responsibility of the Bureau, and that is for regeneration and reforestation. So basically, this kind of also implies their role in monitoring. Kasi how else would they know that there is need for regeneration or reforestation? Of course, there are cases na obvious dahil because of the large scale or or whatnot. Okay, but nonetheless, that's the additional responsibility they have in protecting, developing, and managing forest lands. Okay, what else? They also have a responsibility of regulating and supervising, not only in terms of the issuances of licenses and permits, but also in overseeing the conduct of the licensees and permittees in relation to their obligations. Okay, I think the one thing that needs to be mentioned in relation to this is the purpose behind these licenses and permits. As I said, we're not just talking about protection of forest lands, but we're also talking about the uses of them. Because the law does allow people to benefit from them by using those resources. Okay, so in order that such use is not abused, syempre kailangan set up ng guidelines and rules on what can be used and what cannot be used, what can be done and cannot be done. Okay, and the way to make sure that people comply to those rules is to oversee as to who is qualified and who may be entitled or who may be allowed to be given or granted those licenses or permits. Okay, and those licenses and permits are also serving as an agreement. Okay, they're serving as an agreement that not only discusses exactly what they are able to do or not. Okay, or that the process of getting one also involves orienting the applicants on what they can and cannot do. So besides, maybe the permits already have some specifics in the permit itself, but in addition to that, there's also the application process that ensures that information is effectively relayed to the applicant. Okay, the applicant, on the other hand, attests by receiving that applicant the license in their application process. They're attesting that they do understand what those obligations are and that they're going to comply to them. So in that regard, it's serving as an agreement. Okay, so the Bureau is responsible for the issuances of and the monitoring of that. So that's clearly one of their responsibilities. It's pertinent to the objective of this course because naturally people could be in violation of their commitments, and it would require some investigative work by an environmental law enforcer to come to that conclusion. Okay, moving forward. Enforcement of forestry and other laws, rules, and regulations. So this is kind of a general statement, a general responsibility that talks about their roles in enforcement. So clearly, this kind of indicates that they're one agency that you'll find opportunities as an environmental law enforcer. Okay, so since they do have that responsibility of enforcing those laws. Okay. All right, so this responsibility is interesting because the focus of this responsibility is on those entities, mga businesses and whatnot that are responsible or involved in making something or processing something out of wood, something out of the resources, some of the materials that are taken out of the forest. Again, most notably wood. Okay, so the Bureau is also responsible for coming up with laws or rules, in so far as controlling what these entities are able to do and what they're not supposed to be doing. Okay, so that's what regulating is all about. So that may involve setting up particular qualities of wood that can only be processed, by them, or whatnot. Okay, so and again, that also speaks to having that since there's parameters, then there's susceptibility for those laws to be violated. So naturally, an environmental law enforcement agent would have some role in investigating those violations. Okay. Okay, so there are a number of other provisions, two in particular, that I wanted to share. Provisions of PD 705 relative to the functions of the Bureau. Okay, and one of them refers to their role in systems of classification and survey. Okay, so we all should already know by now what classification is. That's the whole process of designating a particular area to be of a particular classification, like a forest land, a grazing land, etc., etc. Okay? That the whole process of classifying, requires some kind of a system, okay? Because you have to, you as the entity, the primary entity in charge of that, are to come up with guidelines as to what constitutes a forest land, a grazing land, and so forth, right? So you have to have a system. Okay. Naturally, there's also talks of surveys because there's a need to determine what are the metes and bounds of the area to be designated, and these essentially are the same surveys that are probably more familiar to us, yung mga gawain ng mga geodetic engineer when there's some disputes as to what constitutes the border between your property and the property of your neighbor. Okay, the geodetic engineer would usually do a survey to determine where that border is. So it's the same here, and again, it's specifically to determine what are the metes and bounds for a particular piece of land that's being classified. Okay, a particular piece of forest land. Okay, so system of classification and survey, that's one the responsibility the Bureau has. Another, and probably more broadly aligned with the objectives of the law, and that is to ensure that there is balance and optimum utilization, as well as equitable and sustainable management. When we say balance and optimum, let's talk about balance first. Dahil nga there is that contradiction between protection and actually, they refer to it as exploitation, but that has a negative connotation. But probably better to just use utilization. Yung pag ginagamit mo yung mga resources ng forest land, many times they refer to it as exploitation. But anyway, there's a contradiction dahil nga, there's a need to protect it so it doesn't get depleted, yung mga resources. But at the same time, there's an allowance for its usage, its utilization. So, where do you draw the line? And that's where the balance comes in. There's got to be a balance as to how much can be used and what not. Okay, and in terms of optimum, syempre, it's just the most that you can get out of it. So that's the whole idea behind it. Since these very important resources are very, very rich, so you're gonna want to try to make sure that people are able to get the most out of it without compromising the limited resources, or possibly even putting such resources in danger of depletion. Okay. In terms of equitable and sustainable management, sustainable management refers to the management of what's being used, and when we say sustainable, we're really just talking about renewable. That kung syempre pag mangolekta, you're cutting down trees and whatnot, the kinds that's allowed, right? You're you have a permit to cut down trees. Okay, there has to be some kind of a management plan to ensure that that those trees that are cut down, that there's some kind of a reparation. There's a replacement. Maybe new trees are planted, and of course there's some limits as to how many trees can be cut. So in any case, the sustainable really just talks about that it's renewable, that it's not just you cut it one time and that's the end of it. That there is some possibility that it can be renewed over time. Okay, and equitable, again, it's fair. We're talking about fairness there, especially as it relates to some of the obligations of the licensees and permittees. Okay, because being able to use those resources doesn't mean it's something that you can do for free. There are fees, charges, and even taxes that come with it. So we're really only talking about, in this case, equitable, fair in those charges. Okay. All right. So let's move forward. In terms of specifics on this balance and optimum utilization, as well as equitable and sustainable management, the law identifies or enumerates particular areas. For example, on timber resources, wood processing, reforestation, special uses, licensing, permitting, qualifications, and lastly, in the imposition of regulatory fees, charges, or taxes. Okay. So PD 705, as it relates to the organizations that are mandated to implement its provisions, there's a relatively recent development. Well, first of all, as a general statement, PD 705, as I've said earlier, is a very old law. 1975 pa siya na implement. It was put into effect then. And there has since been a number of amendments. But what is of interesting note to make is that none of those amendments completely repealed it. Yung mga amendments na yon just amended particular provisions. So essentially to this day, PD 705 is still in effect, save for those provisions that has since been amended by other laws. Speaking of amendments, as it relates to the Bureau of Forest Development, there was an executive order which was purposed on reorganizing the Department of Environment and Natural Resources. And that same executive order, what it did was it essentially made it so we are today no longer seeing the existence of the Bureau of Forest Development. Instead, this Bureau of Forest Development, under the executive order, made it so it's absorbed into a new bureau called the Forest Management Bureau. So the BFD is now FMB. In addition, there was another government agency that was also absorbed by it. But for the most part, the provisions of 705 as it relates to the responsibilities and mandates of FMB, or rather the BFD, remain still current, but now under the auspices of the Forest Management Bureau. So now we are done with some of the preliminary areas of the law that we wanted to cover. We are now in a position to talk about more meaningful areas, at least meaningful as it relates to the objective of this course. Okay, so we're going to be talking about the sanctions. Essentially, these are the criminal offenses and penalties that are covered or defined and penalized under PD 705. Okay, so the question that we seek to gain answers for here really are, what are the acts that are punishable under PD 705? Okay, so let's enumerate them. There's about 11 of them. Okay, There's the cutting, gathering, and or collecting timber or other forest products without license. Okay. Important point here is, and I think we've said this more than once, is yung pagkakat, pagkagather, pagko-collect ng mga timber and other forest products, okay, is not criminal per se. Di ba nga sabi natin, the law does provide for people to be able to use those resources. Okay, so being able to cut, gather, and collect is not per se unlawful. Okay, but what makes it unlawful is if it's done without license. Okay, so that is the qualifier that makes it a crime. All right, so we'll talk more about that in a minute. So let's just quickly proceed to enumerate the other crimes under this law. Unlawful occupation or destruction of forest lands and grazing lands, pasturing livestock, illegal occupation of national park systems and recreation areas, and vandalism therein. So a lot of these we're seeing that they are by their very nature unlawful. Besides the fact that the title already identifies them as such. Okay. So number 5 here is destruction of wildlife resources, survey by unauthorized persons, misclassification and survey by government officials or employees, issuance of tax declaration on real property without a certification. So you'll see these last 3 refers to misdeeds by public officials or employees of the government. Okay. What else is there? There's let's see, we go to number 9, coercion and influence, failure in the payment, collection, and remittance of forest charges, and the last one is sale of wood products that are non-compliant with government grading standards. Okay, so these are the enumeration of the 11 acts that the law says are a crime, and then it provides punishment for it. So naturally, these enumeration by themselves don't tell us how exactly they're violated, how exactly do they become a crime. Excuse me. If you're an investigator, environmental enforcement agent, you're going to want to know specifics, but you're going to want to know the elements of each of these offenses in order to see if those elements were met, by the act of the person. If the act of the person is such that is consistent with the act as defined to be a crime, then it might be a violation or a crime. Okay, and just the same, whether who would be the right person that can be considered an offender on this crime. Sabi nga natin when I was talking about number 7, 8, and 9, those are specifically for unlawful acts by government officials and employees. And then the others very well maybe just any person could be liable for it. So anyhow, this enumeration doesn't tell all of that, doesn't give all of that detail. But in the provisions of law, it does provide those specific definitions containing the details that we seek, okay, and even provides specifically the punishment. All right, so let's look at a number of them. I don't want to go through all 11 kasi medyo mahaba-haba to. I think what I'll do is I'll demonstrate here. We'll do an exercise. We'll look at maybe 2 or 3 just to give you kind of an idea of how to determine what the elements are. Something that you might be able to use in time when you are a environmental enforcement agent. Okay, so we're going to go through that exercise on maybe 2 or 3 of these, and then on your spare time maybe you could use those same exercises and maybe even come up with your own to help you determine specifically if a particular act that you've observed, you've read about, something that you might be interested in investigating, to see if indeed those are in compliance with the elements for it to be considered a crime. Okay, so let's do that. Let's look at number one: cutting, gathering, or collecting. Okay, so let's look at the specific provision in the law about that. Okay, this is it. This is the actual provision. It's a paragraph long, medyo mahaba-haba, very legal. Okay, and it looks like this. You can do this on Excel spreadsheet or even in Word, and basically it's just a table where the leftmost column are the particulars, the elements, okay, the necessary elements for this crime to be considered as such according to the provision of this law, right? So the first row in that column is the offender. Below that is the act, but not just the act, but possibly omission. Because remember, a crime isn't necessarily a positive act by itself. It's not just about you as the criminal actually doing the offense, but it could be that you failed to do what you were supposed to do. The law might say you're in particular times you're supposed to do this, but you didn't do it, and in such cases, then that omission would still be considered a crime. Okay, so that's the reason why I have on here act or omission. Okay, and the last item on the bottommost row is, if applicable, what would be the qualifier? What would be the particular circumstance, act, or want that was not accomplished that makes this a crime? Because those are cases where the act or omission by themselves do not constitute the crime. Okay, in other words, the act itself is by its very nature not criminal, but there is something that would have had to have been done for that to be a crime, and that's where that qualifier is purposed on. Okay, so let's go back. I have now this worksheet up on the screen, and let's look at the markup that we did kanina, which is now on the bottom of the screen, and let's fill in the blanks, so to speak. So there's three circumstances. Let's first look at the first one. The offender in that first circumstance is any person, and the act or omission is what I underlined in the beginning of the sentence. Okay, that's the actual cutting, gathering, collecting, etc., etc. And we said that that particular act by itself is not a crime. There has to be something to qualify it, and that's the first phrase that I highlighted. Okay, without authority. So those three things essentially are the elements of the crime. So if those three things concur or is consistent with the act of a particular person, he could essentially be in violation of the law. Of course, it's not yet conclusive. The court is the one that will determine beyond reasonable doubt, diba? Especially in criminal cases, if indeed those elements were present. Okay. But as an investigator, syempre, you're going to want to try to get as close to that as possible. All right. So this is one way to help you in that determination. Okay. So there you have it for the first circumstance. I think I did one for the second and third circumstance. Let's take a look. So for the second circumstance, it's also pertinent to any person. Kasi, that first sentence is connected with the second circumstance. The first sentence being the first circumstance. The second circumstance, they're kind of in the same sentence, pero they're conjoined by the or, right? That's the conjunction, the or. Say yung first was the actual cutting, okay? And then the second is the possession, okay? But they still refer to the offender being any person. They refer to any person as the offender, okay? Now the act there, as I said, it's not the actual cutting, collecting, etc., but the possessing of timber or other forest products. And like the first circumstance, the act of possessing is not necessarily illegal or criminal. There has to be a qualifier, and the qualifier is the second phrase that I highlighted, and that is without the legal documents as required under existing forest law, forest laws and regulation. Okay, so yeah. Now let's take a look at the third. Put that also on the table. We know that it is not just any person that we're referring to as a potential offender. It has to actually be an officer of a partnership, association, or corporation, and his act is that of ordering, ordering the acts that we talked about earlier, the act of actually cutting, gathering, and collecting, and of possession. Okay, and since those two acts, are not by themselves criminal, they're qualified by something that makes it criminal. So too will this circumstance require those qualifiers. Okay, so as it pertains to the cutting, gathering, it is without authority that qualifies it. So in other words, if the person that was ordered to cut and gather, did so without authority, then it is a violation of this act. Or if the person, let me take that back. If the officer ordered, if the officer ordered a person, maybe one of his staff, to cut and gather as well as collect, and that person did not have the authority, then it's a violation of this law, against the officer. Likewise, if the officer in this case, ordered one of his personnel, mga tauhan niya maybe, to possess timber and whatnot, and that possession was done without any legal document that allows them to do such, then the officer would also be liable against this law. So there you have it. That's how you would analyze and attempt to make sense of what constitutes a violation. So back at this enumeration, let's maybe do one more. Perhaps this is one that would be less confusing, a little easier. We'll see. But let's go ahead and pick one more, and we'll do the same exercise that we did just moments ago, just to see, given a slightly different definition, how we would analyze to come up with the elements of the crime. So why don't we take a look at pasturing livestock. So here is the actual language of the law, where we would find the definition of the crime, like who would be the person, who would be the offender, what would be his act, and what are the punishments. So this one is interesting kasi yung pag-compose nila ng provision medyo iba. It's and that's natural kasi every lawmaker will have their own style. So this is an interesting example. We did earlier, when we looked at the earlier example, the earlier provision that we analyzed, the answers were given to us. Kahit na medyo mahaba-haba yung provision, medyo madali nang alamin kung sino yung nag-commit, who did it, what was the act, and what needed occur, what is the qualifier. So again, that was even if there were three circumstances which made it a little confusing, the point remains that the way they structured their sentences, medyo sequential, that follows how to answer these three questions. This time around, even if the particular crime seems simple enough, the way they structured the definition is a little different. So it takes a little bit of reading and thinking it through to make sure that you're able to come up with the true elements to determine if the act that you may have observed is indeed a violation of this particular provision. So it's weird because it starts to talk about the penalty first. So you sort of have to read through it and skip all of the discussions about the penalty and look for the start of where it talks about who may be the offender and what might be his acts, and if any, what qualifiers might there be for this to be considered a crime. Okay, so let's read through this. But if you actually go down, just to make it easier, if you go down to the third line, okay, towards the end of the sentence where it begins to say shall be imposed upon, okay, that's really the start of the portion of the provision where we would identify, or we would find the answers to these three questions. Okay, so shall be imposed upon any person. Okay, so there you have it. We can already see that it identified for us who the possible offender could be, and in this case it's any person. Okay, the sentence goes on to say who shall, without authority under a lease or permit, graze or cause to graze livestock in forest lands, grazing lands, and alienable and disposable lands which have not as yet been disposed of in accordance with the Public Land Act. Okay, so it's also a little out of the ordinary kasi it begins to talk about the particular act, okay, which may need a qualifier, but before it actually proceeds with the sentence, it inserts, interestingly enough, the qualifier. You see, it says, shall be imposed upon any person who shall, and then before talking about exactly what the act is, it qualifies it already. Who shall, without authority under a lease or permit. There's the qualifier, okay? And here's the act. The act is graze or cause to graze livestock in blah, 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 blah. Okay? So, a little different, but, you could, by reading it a few times, you would be able to analyze it to come up with these three questions, the answers to these three questions, which in essence provide the element of the offense. Okay? So why don't we put that in the table or the worksheet that I created to make it easier for us. Okay, so again, we know that the offender here is any person. Okay, and like I said, when we were reading this, we found that they inserted the qualifier first, and we know the qualifier to be that it is that whatever the act is was done without authority under a lease or permit. And that act or omission follows, and it reads for some of the other violations that are identified here in PD 705. There's 11 of them, and we only talked about 2 so far. Okay, so you have more than plenty to practice with. So again, I would encourage you, just to help you para mahasa, kumbaga. It's in a way, to kind of develop the skills to come up with the elements of the offense, so that as an investigator, you're easily able to determine if a particular act that you've observed in your investigation, or based on evidence that you've collected, that you're analyzing, if based on all that information, if indeed there is a violation of law that warrants further legal action against the offender. Okay, so again, take the model that I have, you're welcome to it, and practice. Try it on the other provisions. Like I said, there are 11 here, criminal provisions, and we've only done 2 so far. You'll want to try to do the others just for practice. Okay, so that being said, we are actually now done with lesson 1A. In other words, we're done with the revised Forestry Code. We now proceed to lesson 1B, and in this lesson we're going to focus on the Chainsaw Act. So when we're talking about the Chainsaw Act, we're really referring to RA 9175, otherwise referred to as the Chainsaw Act of 2002. Okay, so now we want to look at the law to see ano bang purpose ng batas na to, ano yung basis, ano yung dahilan. Okay, so we're gonna be doing this, the same thing that we did with the lesson 1 on the Forestry Code, where we looked at the rationale, and then we went into the organization, and then lastly on the sanctions. So we're gonna do It's similarly, we're going to do that similarly in the Chainsaw Act. Okay, so for now, focus tayo sa rationale. And of course, purpose ng area na to is to get an answer for what is this law all about. All right. So again, we open up the law and take a look to see if it'll tell us what exactly this law is all about. Okay. Now, this is a fairly short law. It's not as verbose, hindi siya masyadong kalakihan, unlike the Forestry Code or maybe some of the other laws. Okay, so medyo mas madali alamin yung mga questions natin, answers to our questions. Okay, so again, for the rationale, usually we can find that on the top part, the beginning of the law. And they're usually either on the whereas clauses, the declaration of policy, and sometimes the title, the way it's titled, could already provide enough information. And that might be the case, in a way is kind of the case, excuse me, here with the Chainsaw Act, okay? Kasi the Chainsaw Act, if you read the official title, okay, an act regulating the ownership, possession, sale, importation, and use of chainsaws, penalizing violations thereof, in a way already provides exactly the answer to our question of what is this law all about. Okay, so but before we conclude that, kasi this is just talking about what it does, right? It's all about chainsaws, and the gist of it is to regulate the ownership, possession, and sale, etc., of chainsaws. Okay, and just the same, providing penal sanctions. So it's a special penal law because it not only regulates, but it also provides a definition of a crime and provides for its penalties. All right, so at least we know that. Pero I think it might be worthwhile to see, like we did in the revised Forestry Code, ano ba yung dahilan? What is the actual basis? Why there is a need to regulate the ownership, possession, sale, importation, and use of chainsaws? What is the real basis? Okay, now this being a short law, it does not have any whereas clauses. However, meron siyang declaration of policy. Okay, and I think in the declaration of policy, we should be able to find the answers we seek. Ano ba yung dahilan? What is the basis as to why there is a need to do this regulating? Okay, so let's take a look at it. Okay, and in looking at it, this is what we're able to determine. First of all, ang objective talaga, okay, as to why there's a need to regulate, points to the state's policy of being able to conserve, develop, and protect the forest resources under sustainable management. Yan yung policy nila that supports the need to regulate. But more importantly, we want to see if there's anything in there that talks about the actual need, not just yung policy, because the policy itself has to also be based on something, right? So, and when in a way, we kind of find it here, okay? Here in this phrase or in this sentence, where it talks about the need to pursue, that the state shall pursue an aggressive forest protection program geared towards eliminating illegal logging and other forms of forest destruction, which are being facilitated with the use of chainsaws. So it doesn't really talk about the problem, but it implies na may problema. Okay, there's a problem with illegal logging and other activities that cause destruction to our forest, to the Philippine forest. Okay, so again, it doesn't give any specifics about that, but it provides implicitly that that's a huge problem, and it blames, in a way, it blames chainsaws as the facilitator of such destruction. Okay, so in a way that already kind of gives us a basis as to why there is a need to regulate the ownership, possession, sale, importation, and use of chainsaws. So now we proceed on to the organization, at least that portion of the exploration into this law. And the question, of course, like the previous law, when we're talking about the organization, we're really asking the question of how does this Chainsaw Act provide in terms of basically, since it's a law that regulates the use, ownership, possession, etc. of chainsaw, the question is, how does the law provide for that? Okay, and I use the word organization because that usually refers to entities that are mandated to ensure that the objectives of the law are provided. Okay, so anyhow, so the question now is, how does this law provide? And there are certain provisions, namely those under sections 4, 5, and 6, where that question is answered. So again, how does this law provide? It's provided through the regulatory measures of RA 9175, namely sections 4, 5, and 6. Okay. Again, the law aims to regulate the use, sale, possession, etc. of chainsaws. Okay. So in these 3 sections, we should find exactly how that is done. Okay. So let's first take a look at section 4. Section 4 says that basically it's the provision that covers who may be authorized to manufacture, to sell, and import chainsaws. Okay, so these are persons who have that authority. So the law goes on to provide the measure in relation to those people. Okay, and what it says is that chainsaws shall only be sold or imported by manufacturers, dealers, and or private owners who are duly authorized by the department. Okay, so the key there, which points back to the word organization, is who has the authority to kind of oversee the manufacture, the importation, and sales, dealership, dealer of basically of chainsaws. And basically, this is talking about the department having the authority. So, question, of course, is kanina we've been talking about the bureau under the DNR, okay, the forestry, formerly the Forestry Management Division, which became the Bureau of Forestry Management. Okay, but now this law, this chainsaw, doesn't refer to a specific bureau, but the department in general, and it didn't even say DNR, but just the department. However, in the definition of terms on this law, it defines what department is. So at least that way, wherever it's mentioned, it refers to how it's defined in the definition of terms. And in the definition of terms, it says department shall refer to the Department of Environmental and Natural Resources. So simple. So basically, whenever we read into this law, any mention of department in proper noun, meaning it's in proper caps, the first letter being capitalized. Okay, whenever we see that, it's really the law is really referring to the DENR. Okay, so again, going back to this provision, it says on here that as part of its regulatory powers, the DNR, okay, are the ones to whom any manufacturer, dealers, and importers must go to before they can conduct their business of selling, manufacturing, and importing chainsaws in the Philippines. Okay, so the DNR is who you would need to get authority to conduct those businesses. Okay, so let's move forward. Section 5 now talks about Section 6. Okay, talks about registration of chainsaws. There's a definite need na hindi porket meron ka na and you were able to acquire it legally, that you can pretty much possess it and then maybe lend it to someone or transfer it or whatever. So bottom line is that there is a need to register chainsaws. Okay, and again, this law provides that the authority that would essentially supervise and regulate the registration, okay, is the department. And the department, of course, is the DNR. That is who a person must register, okay, their chainsaw. Okay. Okay. The second paragraph says every permit to possess and or use a chainsaw for a legitimate purpose shall be valid for 2 years. And then there's a proviso that says that permits to possess and use chainsaw issued to non-commercial orchard and fruit tree farmers. So it talks about the validity, how long it's valid. Okay, and then it goes on to say that for this purpose, the department, the DNR, shall be allowed to collect reasonable registration fees. So, in those cases where there's a duration, there's a period of time, okay, where people are permitted to possess and use in those particular durations, okay, that they are subject to some registration fee, which would be collected by the DNR. Okay, so bottom line is the DNR is the primary agency responsible for the essentially the regulatory measures. Because again, this Chainsaw Act, its purpose is to regulate. Remember, the use, possession, etc. of chainsaws. So the primary agency responsible for those regulatory measures, really, based on sections 4, 5, and 6, is the Department of Environment and Natural Resources.